Hello everyone. As promised in the last lecture, today I am going to talk on do's and don'ts while facing police case. So generally what happen whenever we have to face the police, we became afraid because being a student of science and embedded in our study and cut off from the society, we don't know how to deal with the police. So today I will talk on this topic, and the things which I am going to tell is based on our experience while dealing with such incidences. So the first scenario is incidents of violence against you. So whenever there is an incidence of violence like verbal abuse or physical abuse, you should approach the police at the earliest. Simultaneously consult a legal expert. Narrate the incidents as advised by the legal expert to the police so that the cognizable and non-avoidable offences can be registered against the accused or the persons or the relatives of the patient who has committed violence with you. So while narrating the incidents, you should take care that you should choose such persons as a witness who are reliable so that they will not become hostile against you during the trial. So generally what happens whenever there is an incidence of violence, we go to the police station in a hurry. We are all confused what to tell, what should not be told. Police write something and take our signature, and they take we take the names of the person who are present there, and most of them is our staff members, and police take their statement, and later on what happened when the matter comes to the trial, that staff or that persons are not working with us, and when they came to the court and court when they asked court asked for the our lawyer or the defense lawyer or the prosecution, whoever may ask the questions, they tell that, oh, yes, we don't know everything, we do not remember anything, and police officer has taken the signature of us on a blank paper, and as a result of this, the accused person get acquitted. So this is the most important thing, that we should choose such persons who are reliable, means any of us family member or our friends, persons like this, and you should ensure about the correctness of names of the accused, sections imposed entered in the FIR. So this correctness is extremely important, and the only legal expert can help you in this case, because being a doctor, you are not supposed to know about these things. So whenever there is a such incident, you must have one legal or medico-legal expert who is available at that time. And why this correctness is important? I am showing you one example here. So this is a one FIR which was registered for the violence against a doctor. So in this FIR, you can see that the offense was registered under these sections of IPC, and along with these sections of IPC, the FIR was registered under this MMP Act 1961, Section 3 and 4 of the MMP Act, Maharashtra Medical Practitioners Act. And what are the Section 3 and 4 of MMP are about? These sections are about establishment and incorporation of council and procedure for the elections of the member and the president of the vice president. Means though the section numbers are correct, the wrong act has been imposed, and due to which what happened, these sections of the IPC are bailable. If the FIR would have been registered under section 3 and 4 of this act, I have already told about this in my last lecture. This is a Maharashtra Medical Service Persons and Medicare Service Institution Prevention of Violence and Damage to the or Loss of the Properties Act 2010. And these are its section number 3 and 4, in which the violence is prohibited and penalty for the violence was committed was imprisonment up to 3 years and fine up to 50,000 rupees. And these are the non-bailable sections. Means if the correct act has been written here, the offense, it was difficult for accused to get the bail. Again, there is a one more scenario when there is an incidence of violence or extortion with allegation of medical negligence against you. So In such situation, this act of violence or extortion committed against you can be used as a negotiation tool. We came across such 4 to 5 incidences in last 1 year where relatives ask for money and doctor approaches for advice. We advise him to follow this procedure, and after which patient's party rolled back and the matter ended without registration of the FIR. So what you have to do, we have to follow the same procedure. Whenever there is an incidence of violence, we have to approach the police earliest and consult a legal expert. In that 4 to 5 incidences, that doctor consulted us. We narrated him the incidents, and after taking all precaution, when the opposite party came into picture and the patient approaches the police, and in two cases, even when the opposite party or the patients came to know that or got the knowledge that doctor already went to the police station and filed a case against them, two person did not came to the police. So whenever they approach, we should take a stand that action should be taken in either both or the none cases. Means if the FIR is registered, it will be registered against. If FIR is registered against the doctor, it will also be registered against the patient also for violence or extortion. So this is the most serious scenario when there is an allegation of medical negligence and there is no incidence of violence or extortion. Patient directly files a police case. So at this situation, what should be done? You should not panic. You should keep in mind that you are innocent unless and until declared guilty by the competent court. You should be confident, because due to lack of confidence, you may appear as a guilty. You should keep in mind that after a few time or few months or few years, no one will remember this incident and everything will become normal as it was. We should keep in mind such example in which the doctor successfully survived, and not such examples which doctor gave up. Means there are some incidences where doctor forfeited the practice, left the city, and there are some incidences where doctor thought and later on he acquitted, or though the matter is still pending in the trial court, he is practicing as normal. We should keep in mind the examples of such doctors. Again, you should not take the burden of proof on yourself. You should keep in mind that the burden of proving your innocence is not on you, but the burden of proving your negligence beyond reasonable doubt is on the prosecution, means on the opposite party. So if they fail to prove your guilt beyond reasonable doubt, you will be considered as the innocent. And the situation is not like that. You have to prove yourself innocent beyond reasonable doubt. And if you fail to prove your innocence beyond reasonable doubt, you will be considered as guilty. The situation is not like that. The burden of proving your guilt beyond reasonable doubt is on the opposite party, and remember that, or keep in mind that creating reasonable doubt is always easy rather than proving guilt beyond reasonable doubt. Again, you should keep in mind that you have full right to defend yourself by creating reasonable doubt. Yes, this is the legal and constitutional right of defense provided under the Article 21 of the Constitution, and this right was given to the Ajmal Kasab and the Afzal Guru also. So it is for us, and it is our right, or it is not wrong to enjoy that right. Again, whenever there is a police case or the matter is going on and investigation is going on, don't speak or defend much before public or media, because no one has sympathy with you. Whenever you talk with them, use the templates like investigation and legal proceeding is going on. We have full faith in our judiciary. We will fully cooperate in the investigation, and we will defend our side wherever it is necessary. And we should wait for the results. And I am guilty, and I am innocent unless proven guilty. So second thing is responding to the actions of the police. So along with sending the dead body for the post-mortem, police has a power to seize the hospital, take the case papers and CCTV footage in their possession, and if not seized, police will ask for the case papers and your statement. So this generally happens when relatives of deceased patient are powerful, approach to the police, and after approaching the police take immediate action, and these relatives take a stand that we should not accept the dead body, or they refuse to take the dead body in possession, or to do the funeral of the dead body if no action is taken on against the doctor. And so whenever such a situation occurs, we hardly anything we can be done, because at that time things are beyond our control. But if this thing has not happened, whenever the case papers, police officer ask for the case paper, don't give the case papers and the statement in a hurry. This point is most important. Generally, what happened? Doctor hand over the case papers to the relative or police and give the statement, and then approach to us and says that they were hurriedly asking, so we have to deliver. So whenever police officer asks for the case papers or the statement, for the case papers, ask for written demand of the statement and case papers along with the details of the allegation. So you have a right to ask for the written demand, and you have to ask for the copy of the complaint. So this should be asked, and after receiving this demand and the copy of the complaint, so you should consult a legal and the medical expert for drafting the statement and checking the case papers. Legal expert will help in drafting the statement because he know how to deal with the allegations, and medical expert will help in checking the case papers. Again, don't believe on the words of the police. They may pretend as your well-wisher, but reality may be different. So generally what happened, police do not threaten us. Sometimes they speak very friendly with us. Don't worry sir, we are here, nothing will happen, but the reality may be different. So what precautions should be taken while drafting the statements? So these points are most important and should be kept in mind that statements of all doctors and staff, case papers, CCTV footage are the most important as they are the base of the proceeding. So there must be uniformity in all statements, case papers and CCTV footage. So whenever you draft the statement, you should draft the statement in such a way that after reading the statement, it should appear that this case comes under the general exceptions of BNS. Which are the general exceptions? These general exceptions are section 14 to 44. I have already told about these sections in my last lecture. And I also told in the last lecture that in the upcoming lecture, I will told you how to use them. Again, statements should be easy to understand, just like reading a story. Allegations which are not in the complaint should not be defended. Our statements should be limited up to the defending the allegations which are in the complaint. And if police sees the case paper in hurry without giving opportunity to complete it, this fact should be described in the statement, and the pages of the case paper should be numbered, and whenever you deliver or hand over that case papers and the statements to the police, you should take the acknowledgement. Because generally what happens, most of the time the statements are not signed and the police officer may later on change it. Again, the content of the statement should be same at all stages of proceeding. Means there are the different stages of the proceeding. Just like suppose giving statement to the police before registration of FIR, again defending the trial, statement while defending the trial, again statement while defending the bail application. So at all and in all proceedings. So what happens generally, patients file the case at different authorities like civil court, criminal court, regulatory authorities like MMC and consumer forum. So because of the same case facts, the facts as will be same and that will never change. So the same, once the statement has been prepared, it should be same at all levels of the proceeding and in the all proceedings, whether it may be civil, consumer or regulatory body or before the nursing home registration authority. So after taking statement from you, you should keep surveillance on what is going on when the matter has been sent for the opinion of the expert committee. So if the opinion of the expert committee is in your favor, though it is not binding on the police, generally police officer will not register the FIR. If expert committee opinion is unfavorable, you can appeal before the state committee, and if you do not appeal before the state committee, FIR will be registered against you. So the commonly offense is registered under the bailable sections, but exceptionally it may be registered under the non-bailable section. This thing I have already told you in the last lecture, and I have also told you the examples, some examples where offense was registered under non-bailable sections. So it is always safer to hide yourself after registration of FIR till you become sure that all imposed sections are bailable. And from here you can get these details. You can get these details either directly from the police station or from local news reporter whose job is to go to the police station daily and take the details of the FIR register so that they can be published in the newspaper, or from online portal of a police department, or from JMFC code on the second day if the offence is registered under non-bailable section. So if all imposed sections are bailable, then nothing to worry. What is meant by bailable section? So police or the court has to release the accused on bail if the accused is already ready to take the bail. Means accused can claim bail as a matter of right. Keep in mind that though FIR is registered, you are still innocent. Don't worry, follow your routine life, because police can't pick you from your hospital. Police can call you in the police station for investigation. Police can conduct the investigation only in the daytime. Police can't call you in the night. Police can't keep you in the police station during night. Though you go to the police in the evening, police officer has to release you before sunset. For completing formality of bail, you and police can decide the time by your mutual convenience. So getting bail in the bailable section is just a formality and clerical procedure. If any of the imposed section is non-bailable, then what is meant by non-bailable section? To decide whether accused be released on bail is the court's right. It is not the right of the accused to be released on the bail. Court will decide whether you have to be released on bail or not. So what you should do? You should hide yourself. Though you are still innocent, police can pick you anytime. Apply for anticipatory bail. Again, don't appear in public until you receive the bail order, and can follow your routine life after getting the bail order. And after getting bail order, if there are the sufficient grounds, you can apply before the High Court for quashing the FIR. Again, insist the IO to apply before the trial court in a charge sheet for taking action against the informant under section 217 of the BNS. This section I have already explained in the last lecture, that this is about giving false information to the police officer, and when it appears that the informant gave false information to the police. Again, apply for the discharge before commencement of the trial. If there are sufficient grounds for the quashing of the FIR and you have not applied for the quashing of the FIR, you can apply for the discharge before commencement of the trial. Means suppose there is a case in which there is a death of a pregnant woman during the LSCS, and the FIR was registered against both husband and wife is a dentist and husband is a gynecologist. In such case, the wife can apply either for quashing of the FIR or for the discharge. And if these two things had not happened and trial is going on against you, so you can apply for exemption from personal attendance when the prosecution or the court is not ready to conduct the trial. Means court is busy in another work and witness are not present. So in such situation, you can apply for the exemption. Means you have not in this case you have not to attend the court on the every hearing. Your lawyer will tell that whenever it is necessary, my client will appear before the court. So I end my lecture with this quote of Martin Luther King Jr., which says that the ultimate measure of a man is not where he stands in the moment of comfort and convenience, but where he stands at the time of challenge and controversy. So next lecture will be on Consumer Protection Act. Thank you very much.